Welcome to Eckstein Hall and Marquette University Law School. I'm Mike Goucher, and this is On the Issues. This is our continuing series of conversations with news and policymakers, people who are doing interesting, important work in this region and beyond. Today we're talking about the media, freedom of information, and the public's right to know, or need to know, depending on your preference. We're going to be doing that by having a three-person conversation today. Joining me on the far left here is Ben Weisner. Ben is the director of the ACLU's Speech, Privacy, and Technology Project. Ben is part of, I guess we could call it Team Snowden. He's a key legal advisor to Edward Snowden, who, as we all know, revelations about the National Security Agency's surveillance has prompted, I think we could safely say, a national, perhaps even international debate. So thanks to being with us, Ben. Seated next to Ben is Krista Westerberg. Krista is an attorney from Madison. She is vice president of the Wisconsin Freedom of Information Council. And seated next to Krista is Dan Bice. Many of you are familiar with Dan's column in the newspaper, the Milwaukee Journal-Sentinel, the No Quarter column, probably one of the most highly read and perhaps most provocative columns in the newspaper. We would like to thank all three of them for joining us today. Please give them a warm welcome to Marquette Law School. Before we get started, let's say that this is I wanted to say that this is a collaboration between the law school and the Milwaukee Film Festival. Jonathan Jackson is the executive director of the festival. He is here. And Jonathan, you just want to take about 30 seconds to say hello to folks and tell them a little bit about what we're up to.
Thank you for having us here today, Mike, and to the law school. It's an honor to be here today. At the film festival, we believe in the power of movies. That might be an obvious statement, but we believe in the power of movies as a catalyst for community, as a catalyst for engaging discussion. And this forum today and this partnership with Marquette University is the very epitome of that. We're proud. This is the second time that we partnered together. In 2011, we partnered on a series on violence prevention in Milwaukee from the film The Interrupters that we featured. I also want to spotlight the Milwaukee Business Journal, which is the media sponsor of our panel series in the festival. And we're just so proud to be here and proud to partner again with Mike and the law school. So thank you.
All right, Jonathan, thank you very much. The event we're doing today is spinning off the film that was shown on opening night at the film festival. It's called 1971. It was about a citizens group that broke into an FBI office in Media, Pennsylvania, stole a number of documents that led to, well, let's just say quite an interesting discussion in our nation at that moment in its history. What we're going to do for those of you who have seen the movie and for those of you primarily who have not seen it, is show you the 2-minute trailer, which give you an idea of what the movie is about, and then we'll begin our larger conversation on the right to know and freedom of information. So, Ryan, let's look at the trailer.
I knew that we would find things in that office that were not only immoral, but probably illegal.
What we thought of at the time as the war machine. We wanted to do as much damage to it as we could before we got caught.
We knew that if we got caught, we were going to probably face very serious prison time.
It was very empowering to know that ordinary people could actually take action. Philadelphia was full of young families just like ourselves who were very active politically.
I was ready to make a transition from nonviolent protest to nonviolent disruption.
They feared there were FBI informers in their midst.
We heard someone trying to break into one of the apartments in the building. Somebody yelled back, FBI.
Everywhere you went, there was somebody taking your picture. Even the presidents of the United States were afraid of the FBI.
If the FBI was suppressing dissent, it was as important to expose that as it was to end the war.
So many things were so wrong, there was no decision to be made. You have to do something.
Break into an FBI office, remove files, and mail them to newspapers.
More than 1,000 documents were stolen from the FBI office in Media, Pennsylvania.
They called themselves the Citizens Commission to investigate the FBI.
These documents reveal illegal activity by the FBI.
Surveillance of people engaged in protected First Amendment activity.
The fortress was under siege.
150 agents were looking for us. My worry was what would happen to those 3 kids.
This was quite a substantial risk they took.
What happened there is a bunch of ordinary people got together, did an extraordinary thing.
They risked everything. They saw injustice and decided that they were going to act on it.
So that was the opening night movie, the documentary 1971, played to a sellout crowd here in Milwaukee. I thought we'd begin our conversation today by asking Ben Weisner about the parallels between the events of 1971 in Media, Pennsylvania, and Edward Snowden. Are there strong parallels?
Isn't it great that it's called Media, Pennsylvania?
Yeah, no, it is, yeah.
Yeah, there are. I mean, maybe I'll just mention 2, and then we can use those as a launching point. One of them more superficial, and I think one a lot deeper. The first is that one of the things that I've heard a lot in the last year is that valid civil disobedience requires people to accept the criminal punishment that's available. And that if you disagree with the law and you want to be engaged in civil disobedience, you need to stand up and take the punishment. That's never actually been true. Going back to the Tea Party and the Underground Railroad, there's a long tradition of people who didn't, including these patriotic Americans who revealed themselves only 40 years after this crime, and they certainly see themselves as being precursors to Edward Snowden. I think the deeper parallel, though, is that, as you see, this crime, and there's no question it was a crime, what they did, they broke into the FBI office, led fairly directly to the first comprehensive investigation of domestic surveillance in the United States, and the first energetic period of democratic reform over our intelligence community. I don't think that we've had such a period until perhaps now. And the second period of energetic reform over our intelligence community also started with a fairly dramatic act of lawbreaking. There are institutions that are supposed to do oversight without requiring people to take these kinds of risks and break laws. Those institutions generally don't work very well. Our courts have not been eager to step up since 9/11 and act as a check on overzealous intelligence agencies. The people in Congress who are charged with doing intelligence oversight often are the ones who have the closest connection to the intelligence community and not the ones who are most adverse to it. And so sometimes it takes a dramatic act like this of going outside the law in order to reinvigorate the public debate and actually, ironically, reinvigorate the traditional democratic oversight mechanisms.
I have heard Edward Snowden in interviews talk about what he believes to be the public's right to know. In your conversations with him, Ben, how does he describe that? Obviously, he made a decision knowing full well there would be ramifications. How does he define the public's right to know?
Well, actually he made a very careful decision. He didn't want to be the one to decide by himself what the public should know or should not have known. He certainly was technically capable of uploading all those documents to the internet. Instead, he selected a handful of journalists who he thought represented a mix of journalists who were quite aggressive and those who were more establishment, and asked them to use their own professional judgment, that of their editors, in consultation with intelligence agencies and governments, and to publish only those documents that were in the public interest to disclose. Now, obviously, he had his own views. Otherwise, he would not have taken the documents and turned them over to those journalists. But he wanted to create a system that would correct for his own biases, having been in the intelligence community himself for 10 years. But in general, I would say, to go back to your question, he does not believe that a massive global system of dragnet surveillance should be built and deployed without public knowledge or consent. And the debate that we're having right now is the debate that we, in effect, should have had before these programs were deployed and not after.
Dan, let me get a reporter's perspective on this. Somebody comes to you with information, somebody presents information to you. How do you decide what is in the public's interest to know, what shouldn't be published? walk us through the process, the vetting process that goes on.
Sure. Before I do that, I did want to respond to, on the movie, it was pretty interesting to see just how quaint some of the things are in the movie. For instance, I'm assuming Keith, if he were doing this today, would have taken a bunch of selfies of himself during the entire process. And the fact that you could burn files and that's all that exists and it's gone. Today, there's many, many copies of each of these things. But for those of you who don't know, I have one of the greatest jobs in Wisconsin. Every day I go to the office and I have multiple people who are within their departments, agencies, social agencies, offering me ideas. In fact, too many ideas. I can't get to all of them these days with all the cutbacks at the newspaper. But it's a process. I have to decide, first of all, what's most important, what's going to be important to a number of people, and what has the biggest implications. And frequently, I'll be passing out some of these tips to other people. Intern season during the summer is my best time because I'm giving them to everybody the number of ideas. And it's interesting, these Edward Snowden moments don't just happen on a big scale every 10 years. They happen for me every day.
Mm-hmm. Krista, give me your sense of, as someone who is interested in open, transparent government, give me your sense of the public's right to know. It's sort of a nebulous concept. How do you view it?
I look at it through the prism of Wisconsin law, being a Wisconsin attorney, but it's right there in our statutes and our open records and our open meetings law. And there, in both of those laws, the legislature has said a representative government is dependent upon an informed electorate, and therefore the public should have the greatest access to information possible. And it's the job of public servants to make that happen. It's part of their duty. It's not a burden on them. It's what they have to do to enable people to get information, to participate in their democracy. And when you look at it that way, that in most situations, the more information you have, the better democracy you have, then the public's right to know is very expansive.
Do people view it in government as their duty, as their responsibility, as you describe it?
No, not always.
Yeah.
Sometimes custodians feel put upon because they are receiving requests, and it does take away from what they view as their normal work. And, I'm sure in some cases it is a burden on their time, but the flip side of that is the public needs to have the information to do its job and make its choices.
Isn't this this is really the root of the issue, is that the government sometimes perceives the need to know much differently than the media or even the public for that matter.
Yeah, I know. I think that's right. And one of the things that you sometimes hear, particularly in relation to Snowden, is who decides what gives him the right, or Glenn Greenwald, or Bart Gellman, for that matter, the right to override the decisions that were made by elected and appointed officials through a democratic process. But I think if you take a step back from that argument and imagine what we would know and not know if the government successfully maintained its monopoly on information and national security information, even if it was abiding by freedom of information laws, but still only disclosing what it wanted to disclose, what would we have not known in the last 10 years? We wouldn't have known that the case for war in Iraq was trumped up. We wouldn't have known that we tortured prisoners at Abu Ghraib. We wouldn't have known that the CIA set up a network of black site prisons around the world. We wouldn't have known about the first time when the Bush administration disregarded statutory law and conducted warrantless surveillance on American citizens. All of this stuff we know because people in government handed this information to investigative journalists, and those journalists made a decision that the public had a need to know this information and it should be out there. That wasn't a Freedom of Information Act request. That was someone deciding to go outside the rules that the government had set for itself. So there's always been, if you will, a competition between people in government who are trying to preserve their monopoly over what we know and don't know. And enterprising journalists and brave whistleblowers who are creating other channels. And you can think about that kind of whistleblowing as a feature of our democracy, not a bug. It's a kind of safety valve. If we didn't have these alternative channels where information could get to the public, we wouldn't know critical things that go to the heart of who we are, about war, about misconduct, about crimes that our government commits.
Why do people, for example, Dan, come to you, they feel that there are no other avenues for them to express these thoughts or feelings they have about what's happening? Why did they pick you?
One, I have an audience. Two, it's a way to get around the process, to get around what's going on within the agency. We are lucky that the law here is very good on open meetings and open records, and the biggest frustration for me is not so much getting the information, but getting it in a timely way. For instance, in the sheriff's race that was just resolved in August, I made a request in May for some records regarding a pretty interesting situation within the agency, and knowing I was coming here today, I thought I would call them yesterday. I thought I would call them on Friday and ask them what's up with my request, because they decided to take this long to get to it, and they obviously didn't want it out before the election. Those sorts of things are problems. And it's also complicated by the fact that journalists aren't the only ones taking advantage of this. There are agencies in state government where 90% of the requests are coming from private businesses wanting to find out about people dealing with the government. And another issue now is these third-party groups that have come in and hijacked elections. They're coming in and making massive requests for everything that they can, and it slows down the process for those who are trying to do work in the public's interest.
Is it all a good thing, the openness and the transparency? He talks about you have third-party groups coming in, flooding, offices with requests for information. Is it all a good thing? Or I guess as much sunshine as possible, huh?
There can be too much of a good thing. But the open records law in Wisconsin at least accounts for that. It says if there's nothing, your request has to have a reasonable time limitation and subject matter. It has to be, they have to be able to interpret it. And I think that where possible, if you have these log jams, the government can also deal with that by adding staff and doing things on its end and posting more information online. To make it, to avoid having to make a request in the first place. So I think it can be managed.
What's the most common frustration of journalists who are trying to get information from government or from public officials? What do you hear most?
On the Freedom of Information Council, a lot of what we hear is delay, like Dan was just saying, and also cost. Cost of getting records can be really prohibitive. Even before you have seen a page of anything, you can be charged for a location fee, for example, and that might deter you from getting the records at all. So that's a problem.
There was a case in 2010 where a county supervisor had asked for some records that eventually ended up being involved in the John Doe investigation. He made the request. They told him it would be $3,200. He went ahead and agreed to it, and he got 4 sheets of paper. And eventually I wrote about it. They didn't charge the fee, but that's if I hadn't written about it, that would have been that would have been something they had pursued.
I want to jump into this notion of individuals who come forward with information as whistleblowers. And Ben, I want to talk to you about that. You wrote a column for Politico back over a year ago, and you were saying that not all leaks are the same. We need to think a bit about the punishment that we do, and that government should, in many cases, have to justify why information is kept from the public. Talk a little bit about that.
Well, I think the problem is that the law, is this too loud?
Yeah, we're good.
Okay. The law under which whistleblowers in the federal system are being prosecuted is a World War I era law called the Espionage Act. Which really ought to be aimed exclusively at spies, people who sell information to foreign governments for personal profit. And starting in the 1980s, has been used to prosecute people who give information to journalists in the public interest. The problem with the law and the legal regime is that it makes no distinctions between reasons why you might share information. It's not relevant under this law whether the information should not have been withheld from the public in the first place, whether it was improperly classified. It's not relevant under this law whether the information that's disclosed shows that the government was breaking the law or violating human rights. It's not relevant under the law what the motive of the leaker is. None of this stuff comes into play in a prosecution under the Espionage Act at all. The only question is, did the leaker know that the journalist to whom he gave the information was not authorized to receive it? And the answer is always yes. And so I do think that the First Amendment requires that we be a little bit more nuanced in how we use criminal law to go after people. It should not be criminal for someone in government to reveal conduct that's illegal. And I can say that categorically. If someone discloses government activity that breaks the law, that a court says breaks the law, the person who reveals the activity should not be punished for it. And then I think that the system also needs to allow the leaker to mount a public interest defense, to say that the disclosure of this information led to many goods and not harms, and to require the government to show that there was actually harm from the disclosure, which it would have a harder time showing. And instead we have this very, very blunt system that doesn't do those things at all. It doesn't distinguish between an Edward Snowden and a Robert Hansen or an Aldrich Ames.
Mm-hmm. From your perspective, Dan, as a journalist, the whistleblower, are these people who are genuinely worried about their futures, genuinely worried about what could happen to them should it become revealed that they are the ones responsible for certain information?
Sure. Just about every time I'm dealing with a whistleblower, the first step in the process is to negotiate when I might disclose this information, under what circumstances, what could happen to them, the value of the information. That is usually and can be a protracted process. And there have been times when people were not satisfied with the answers I gave them. I did want to follow up on one of your points, and that is, even though we do have a good law here in Wisconsin, there are major gaps in both the Freedom of Information Act and in the state law. For instance, under the Freedom of Information Act, congressmen are exempt from it. So we can't ask for records for members of Congress, and that's very convenient for them. And it also shows that members of Congress are reluctant to actually address this issue because it brings attention to the fact that they have exempted themselves from it. The other one here in Wisconsin, you see these pictures of some of the justices and so forth around the room. Members of the Supreme Court are exempt from the open records law. They get to choose when they release records. And so you asked why certain people would want to come forward. Well, there are instances where there are log jams or cases where records are not going to be made available to the public, and these individuals decide that's the time they want to release this stuff.
Maybe ask you about that. Are there gaps that, from your perspective, the kinds of which we just heard Dan describe?
Oh, sure. And following up on his point about Congress, in Wisconsin, the legislature is subject to the open records law, which is great, but there is no retention requirement for them to keep their records. They carved an exemption out in the law for themselves to actually have to hang on to anything that they get in the course of their official duties. So while they are subject to the law, they can just circumvent it by shredding or deleting anything, as soon as they've read it.
But they would never do that.
No. No. But so certainly there are gaps, and there are things that we are always trying to push on a little bit in the legislature, as well as to prevent the law from getting weakened.
There's just a great deal of self-interest in all of this, and so whistleblowers realize that. Whistleblowers frequently have their own self-interest. Right. They want to protect their own job or something like that, or they're in some sort of trouble. And there are times when people will come to me and say, you're getting used on this story, and I'm like, of course I know I'm getting used on this story, but that's not the issue. Is it valuable to the public for me to write about this? Yes, a lot of these people have agendas, and that's what drives the process.
How has the new means of communication, the digital age, affected this whole discussion? I mean, information is so readily available. It's so easily accessible. You can get this information with a click. And you got to sort through it, but it's amazing how quickly it's in your hands. From the Snowden's case perspective, Ben, people had to publish in a fairly limited amount of time after those documents were leaked. I mean, this is serious stuff.
Yeah, well, I think that technology works in a number of different ways here. When Daniel Ellsberg took the Pentagon Papers from the RAND Corporation, He needed a safe house in Santa Monica with Xerox machines, and he had his teenage kids helping him all night Xerox the 7,000 pages of the Pentagon Papers, and now a couple of thumb drives will get you thousands of Pentagon Papers. When Chelsea, formerly Bradley Manning, took the State Department cables, she was able to do that on a disc while listening to Lady Gaga at a military tent. So it can be much faster in terms of getting information out in huge quantities. It also makes it much more difficult for people in government to do that without detection, or for journalists to have contact with their sources without detection. You hear this term metadata a lot, as if it's a sort of lesser form of surveillance than wiretapping where the content is received. But for investigators, metadata is like having a private investigator all around. The metadata of my phone calls will tell an investigator everyone who I spoke to. So if they see a leak and can get phone records for a reporter, they can trace them to whoever the leaker was. And so what I hear a lot, and I'm sure you hear it too, if you have colleagues in Washington who cover national security, is that apart from these dramatic cases, the conversations that used to take place much more routinely between mid-level people in the bureaucracies and journalists have really dried up because people are afraid of digital detection.
How do you communicate with Edward Snowden?
We do the best we can.
But the fact is, yours is an exception. I mean, for most of us, for everybody in this room, email is crack. We know it's probably going to get us in trouble at some point, but we still do it. And we still, everybody to the highest levels
You're
of government.
glad we do,
yeah,
from your standpoint.
But at the same time, I'm addicted too. I email to people get my emails and they'll write about what I'm saying just as much as other people. But it's great because you think, why in the world did this person do it? Well, we're all connected and we can't help it. When we get an email, we respond right away, right on our iPhone. And that's great for me. Sometimes you're like, why in the world would they do something like that? But I've probably done the same thing.
In terms of accessibility to information, though, Dan, I mean, how has it changed your life as a reporter? The fact that things are so much more readily accessible.
Well, things are faster. Again, with the 1971, we wouldn't have gone 41 years or 42 years without the disclosure because everybody's taking pictures of everything. Mm-hmm. And so many more stories are related to databases and to email digital information. I mean, and the open records system has become much, much more important because it's also incredible. Under Tommy Thompson, I did an open records request for some letter that he wrote in the late 90s, and his response was to say, why don't you have all my letters from the last 5 years? You can just go through them. And they put me in a room and let me just go through everything. And it was incredible. I was able to write stories for 8 months off of what was in that. I do not see Scott Walker saying, oh, here's all my email. You can have it. I don't even think he does that for you guys in the DA's office. So, yeah. I mean, it's everybody's cautious about it though because we all know we've probably written something or sent a joke or done something that we probably shouldn't have done.
From the perspective of the council, this new era that we're in, how has it changed things?
It's mostly, I think, a positive, but you do have problems like, again, with the retention issue. If you want an email that was sent 7 years ago, who knows where it is? It might be on some archived, backup server, and then they'll charge you a location fee of $200 to retrieve it because it's not like you can just search somebody's computer for it now. It's gone. It's in the digital abyss. So that's one thing. Another thing, as far as meetings go, you see some circumvention of the open meetings law. All of the government entities in Wisconsin are, with limited exceptions, supposed to meet in public. But, you have members of a committee or a board or something emailing each other rapid fire, and it's essentially like a meeting. Or like the State Journal did a story a couple of years ago about the Madison City Council, did have its open meeting, but you've got a bunch of the members texting under the table to each other. And so they're essentially having a meeting behind the meeting. And, he was able to get the text messages, I think, because of the open records law. But there are risks, there are problems with it too.
And getting that information is often hard because you'll frequently have to know the information they're requesting. But obviously the mayor of Detroit lost his job as a result of texting to various people stuff that he shouldn't have been texting, or about things he shouldn't have been doing.
Ben Weisner, you're concerned about privacy in this new era. In our desire to know more, in our desire to have as much information as possible, is privacy a casualty in this?
Well, I would put it differently. I would say that there is sometimes a tension between transparency and privacy. There are times where we have to figure out where we want to weigh the balance. An example that I was talking about with some of your colleagues this morning, many cities now have automatic license plate readers, cameras that take thousands of pictures of cars as they go by and retain that information over long periods of time. It ends up being a kind of location database. Now, should that information be available through public records laws? You can make very strong arguments on either side. You could say, we certainly want to know where the chief of police or the mayor or the governor is traveling, and so it would be good to do that. But should anyone in this room be able to do a Public Records Act request to know where my car has been over a 30-day period? That seems like it could be a real violation, and I'm not sure that the public interest in keeping that available outweighs my privacy rights in those instances. So I think we're not dealing here with absolute values when we talk about things like privacy and transparency. We're talking about values that are sometimes in harmony and sometimes in tension, and figuring out where to draw those lines is going to be the work of our generation.
The difficulty is once it's out, it's hard to pull it back. And there's a story in the New Yorker just this week about a case where there was a particularly gruesome accident, and members of the California Highway Patrol decided it would be hilarious to send the pictures of the autopsy to some friends, and then they forwarded it, and now that picture is out on thousands of websites, and the family is fighting to get the pictures back. How do you do that? It's a very, right. It shows how important the decisions are early in the process and the unintended consequences that come when you make a decision to publish.
Right, and so in that instance, I would support punishing the people who engaged in the initial privacy violation, but I would be opposed to any legal effort to require, for example, a news website to take the pictures down.
And in Europe, they've made a different decision where in Europe, Google has a responsibility to make a decision whether to pull back, but the news organizations do not.
I want to follow up on what Dan was saying with Krista. I was talking to somebody here who is an academic and had worked at another university, a public university, and he was talking about the fact that just routine emails, which you talked about, Dan, but routine emails, just conversations that colleagues have among one another, we're increasingly becoming the subject of requests for public information. And he said it, and it was really chilling. He said it destroyed the whole atmosphere of collegiality. You were afraid that any time you might say something that could be considered by someone to be expressing an opinion, he said people just didn't want to even speak by email anymore. Is that one of the dangers that we have there when everything is essentially at a public institution is open to a public records request, or most everything?
Yeah, I've never worked in government, so I can't speak to what that would feel like. But I do, state agencies and entities that are, typically subject to the law are, dealt with that for a long time, and you do see maybe more of it creeping into the public university settings. And Bill Cronin at the UW has written about that extensively, and he had to deal with that issue in a very public way, and has written some really interesting things about it.
Mm-hmm. I still don't see very many people pulling back, though. I mean, it's usually after the fact, after you've gotten something published, that you say, crap, why did I do that? Mm-hmm. It's not in advance that most people are no longer communicating. Mm-hmm.
I want to, we're going to open it up to questions from the audience here in a moment. But what I wanted to do is, I did want to ask Ben this question. In some of the promotions, even for this event, we mentioned Julian Assange. I would imagine that you would want to make a distinction between what Edward Snowden did and what Julian Assange has done. Is that a fair point to make?
Well, I think that there's more than one Julian Assange in this story, that if you look at the way that WikiLeaks operated early on, they operated in a way that is more similar to what Snowden has done, in the sense that they chose journalistic partners to publish with. The State Department cables, they partnered with Der Spiegel in Germany, with The Guardian in the United Kingdom, and with the New York Times here, and relied on the expertise and relationships of those institutions in order to decide what to publish and what to withhold. I think over time, they grew frustrated with that model and decided that the better way to do it was to put almost everything out there and sort of let the chips fall where they may. That's not the decision that Snowden made. His decision was to engage in what he considered to be a tried and true process that has existed in this country over decades, of allowing professional journalists and their institutions to engage in those conversations with government and to hammer out reasonable results. But Snowden and we, have been criticized from both sides, have been criticized certainly from people who think that he gave much too much information to journalists, and criticized by people who think that he has no right, and the journalists have no right, to decide what the public should see and not see, and they should publish everything. I don't know that there is a one-size-fits-all answer to this question.
It's interesting that in the documentary how the different media organizations respond to the information they get. The Los Angeles Times and New York Times decide, we're going to head right back to the FBI and give them back what we got. Whereas the Washington Post makes the brave decision. And when I see the New York Times, Los Angeles Times doing that, I'm like panicking. Why'd you do that? Whereas the Washington Post makes the decision. But much of it's based on relationships, too. I'm assuming Edward had relationships with, and he did, with some of the people in terms of who he's communicating with.
It's more people who he had watched and chosen based on what he had seen about how journalism had performed. For him, one of the sort of signal events is in 2004, when a Department of Justice whistleblower gives critical information to Eric Lischblau and James Risen of the New York Times, two excellent reporters, about illegal NSA wiretapping. And the White House persuades the New York Times not to publish that information for 14 months through the 2004 election. And it's not clear the New York Times ever would have published that, but for the fact that James Risen was about to publish it in a book. And so they eventually published that. And he didn't want to put all of his eggs in one basket. He chose someone like Glenn Greenwald, who he understood to be a more pugnacious kind of reporter than that, and also someone like Bart Gellman, a more established reporter, so that he could push the more mainstream entities into the reporting game.
Now, Glenn's a little bit more ideological. He's openly ideological. What can you say the decision why he decided to go with Bart Gellman's known as more, straight and narrow, impartial, down the line sort of reporter?
Yeah, I think part of what he was aiming for was competition rather than monopoly. The New York Times had a monopoly on that leak, and therefore they were able to prevent the public from seeing it at a critical time. Whereas if you multiply the number of entities that have something, then you reduce the chance that something in the public interest will be withheld because of one relationship or one conversation. But Bart Gellman is someone who had done a lot of adversarial journalism, had won a couple of Pulitzer Prizes, had written a book about Cheney, really knew surveillance, really knew technology. I think it was a really excellent choice. And, I think the journalism that the Washington Post has done in the last 15 months has been heroic and extraordinary.
A couple of final quick questions. We'll take your questions. Again, Ben, just because of the Snowden case and the interest in it. Do you think any serious damage has been done to long-term security interests of this nation, other nations, because of the leaks?
I don't think so. I certainly haven't seen anything persuasive in the public record. When you see the intelligence community coming forward or ideological members of Congress saying terrorists are now changing their communication, I think you need to take that with a grain of salt. They certainly were using encryption before. They're certainly still using it now. If the point that's being made is that we've now, driven terrorists back to the Stone Age, the way we did with bin Laden, who was communicating by carrier pigeon and wasn't connected at all to anybody, that's probably better for national security, not worse. So I don't actually give so much credence to that argument. I don't think those arguments age particularly well. But I will say that I think a lot of these disclosures have made us more secure. And if you talk to security and technology experts, they will say that the changes in technology that have followed the Snowden revelations, the ways that companies like Google and Apple and Yahoo have improved their security and improved their encryption, have made us more secure from hackers, from cyber attacks. Before Snowden, our national security officials were telling Congress that cybersecurity was a bigger threat to this country than terrorism. The technological changes that have flowed from the Snowden revelations have improved our defenses against cyber attacks.
And do you see him returning to the U.S.
I hope
someday
so.
soon?
Yeah, well, it depends what you mean by soon. But I hope so.
All right, let's take questions from the audience. For the people in the seating bowl, please press down on the rim, not on the little ball, but on the rim. Keep your finger down on that, and we'll be able to hear your question. If you're in the back, raise your hand, and we'll have Ryan, who has a microphone, come by and have you speak into that. So let me take the first question. Gentleman in the blue shirt back here.
To kind of go off of that last question about whether or not Snowden will ever come back, has there been any contact from national security officials or the Justice Department to you as an advisor or representative about potentially having him come back and face a trial that would be perhaps modified and allow the public interest defense or motivation into the proceedings?
So if people didn't hear the question is, have we had any conversations with the United States government about what circumstances would allow Edward Snowden to come back to the United States? And the answer is, of course we have. For all along, there's been open communications between us and the government, not about whether they would change the law so that he could face trial under different circumstances. That's not something that they're interested in talking about. But they're certainly interested in what crimes he might plead guilty to and how much time he would serve in prison. And those conversations will continue. The door is open. I wouldn't say that we're necessarily in the same universe yet in terms of what we think the proper outcome is to this dispute, but yes, we are having. I won't say more about it. I don't think that we should be having these conversations with the government through the press or the public. Yeah.
Other questions? Yes, sir.
Oh, here we.
Yeah.
In regards to who we let the information out, contacting the media, was there ever any thought or attempt to go to a member of Congress or the Justice Department to let it out instead of letting it be a Wild Wild West situation? And two,
that's a big question. You're going to ask another?
Okay. Two, a related question, if your sanctuary is Russia in protest of being surveillance, you kind of screwed things up here, I think.
Let me take the second one first.
Is that the easier one?
Yeah.
Well, no, I think they're both. I think they're both important and difficult questions. There's no question that it's awkward that there are only two places where he can be right now. One is receiving asylum and essentially safety in a country like Russia. And the other is in a solitary confinement cell serving probably a life sentence in the United States. If there is a third option, he would take it. But there is no question that's awkward and uncomfortable for him. If you follow this closely, you'll know that he has written and spoken very critically about the Russian surveillance regime, wrote an op-ed in The Guardian in which he was very critical of Russian surveillance practices. In the interview he did for NBC News with Brian Williams, he repeated those criticisms and even expanded them. But that's awkward. It's not an ideal situation. On the flip side of that, many people from around the world sought refuge and asylum in the United States during the Bush administration because they were fleeing persecution. They were not thereby endorsing Abu Ghraib, waterboarding, secret prisons, drone strikes. They were coming here because of what they were escaping from, not because they were endorsing all of the bad acts of our government. So I don't think that asylum equals endorsement. On the question of whether he had alternative channels, he certainly did raise his concerns as much as he could within the channels that existed in his agencies. The problem is that this was not someone who had stumbled upon one dramatic act of lawbreaking or wrongdoing. This is someone who saw an entire surveillance regime that had been deployed and approved in secret. So had he gone to the Senate intelligence community, maybe he would have said something like this: "Hi, I am a 29-year-old contractor, and I'm calling to tell you about programs that you've approved in secret." I don't think that really would have worked. What was missing from the discussion was the public. And the way to bring the public in responsibly was to go through professional journalists, and that's what he did.
Other questions? Gentleman up here in the back. Ryan, you want to hang on? And just 1 second, please. No, not loud enough for us, no.
We're all sitting here, and many of us are just citizens, just public. And what defense do we have against a very powerful government who does do things illegally but doesn't seem to be brought to court for them? And what I'd suggest is policemen are usually required to wear their uniforms, even though they send ununiformed policemen in to survey. And I would like to ask, is it proper to ask the operatives that are here in the audience and the cameras that are on us what surveillance they're doing, what violation of our rights to a public assembly? Would they stand up, the operatives, and identify their secret missions to undermine our discussions here?
Yeah, go
what
ahead.
Defense do we have?
Everybody.
Anybody have anything they'd like to say to that?
No, I think that was an utterly complete statement.
I do have one comment that's not exactly related to that, but a lot of the discussion has been about whistleblowers and bringing illegal acts forward, through revealing documents to journalists or posting them online. But not to be a wet blanket on that kind of sexy topic, but a lot of the records that you get from the government or that people pursue from the government are not about illegal acts, but about acts that are perfectly legal for the government to do and have been approved by Congress, like Ben was just saying. And the public just really hasn't had an opportunity to have a robust discussion about that. And one example I would raise would be, after the events in Ferguson, Missouri, we learned about militarization of local police departments. And, this is a Pentagon program that had been instituted and to give basically military-grade equipment to, sometimes very small police departments. And, and after that happened, after, this very visible show of that force in Ferguson, you have, I think, a lot of journalists and even members of the public doing open government requests and getting documents about the extent of the program, nationally and in their own communities. We had reporting, I think, by Wisconsin Public Radio and probably others, how many police departments in the state have these, these anti-IED vehicles. It turns out quite a few. So I think, it's not a leak, but it's still very interesting, and it allows us to decide how we want to be governed.
So the idea isn't that we're looking at what's being done that's wrong, but it helps us learn what is actually going on.
Mm-hmm. And to make choices about, is this something that we should continue doing as a democracy?
Mm-hmm. Other questions? Yeah, Jonathan, since it's your film festival, you can ask a question. Yeah.
Thank you. This is a question that actually jumps from the discussion on opening night of 1971 that I hadn't thought about, and it was from Betty Metzger, the reporter for the Washington Post that wrote the story, and she commented interestingly on how the changes that did come and the focus after that 1971 discovery might not have happened had the personalities, had the people revealed themselves, because then the media may have focused more on their story and their personality. And so first I'd have a question for Ben on if that is an issue for their team, with people focusing more on just the motivations or the personality or who Edward Snowden is. And then to Dan, some people here I think might argue that sometimes your stories focus really heavily on the personality and not as much on the actual information or the story itself, and how you balance that issue yourself.
So let me try to answer that for Team Snowden. It was a huge concern of his in deciding whether to identify himself. Ultimately, he identified himself early on for a number of reasons. He wanted to prevent his colleagues in the intelligence community from undergoing the kind of really intense investigation that would have taken place had he not pointed the finger at himself. To be sure, there was a pretty serious investigation anyway, and a lot of people were interviewed and subjected to polygraph exams, but it would have been much worse if they were trying to ferret out the leaker. Number two, he thought that he owed the public some explanation of why he had done what he had done. But you'll notice that after he went public in June of 2013, he didn't appear again in television until June of 2014. That was not for lack of interest. I had to change my cell phone number so that I wouldn't be called every minute by the Today Show. I mean, every news organization in the world wanted to report on him, and if you saw the reporting from back in June, it was, you know, focusing on where he went to high school and dropped out, who his girlfriend was, images of her dancing, all of that intense personal focus. And what's remarkable is that the information that was published was so rich and so important that it really drowned out a lot of that personal stuff, enabled a lot of the reporting to be done. And he waited a year until, you know, The Guardian and The Washington Post had won Pulitzer Prizes, until courts had held some of these programs unconstitutional, until Congress was well on its way towards reform, until technology companies had changed their systems, before sitting down with an American TV news anchor and answering, you know, the questions that people had on their mind. But all the time, it takes a lot of work to keep the focus on the disclosures and not the discloser.
Guilty. I do write a lot about personalities. It's a column I've been given. It's a great thing. You know, I originally started writing it with Carrie Spivak. Carrie's gone back to doing investigative reporting exclusively. I try to write what's interesting to me. For every column that I write, I probably kill off two or three, and I make a decision on what interests me about a story. Sometimes it's the issue, sometimes it's the personalities, and it can differ. And frequently, you have to see what I'm writing within the flow of news. If someone else has written about a particular issue, I'm sometimes responding to it and telling you something you didn't know about that particular thing. So, but you're right, I do write about personalities, but I think that's how I end up getting, you know, hundreds of comments on everything I write. It's usually 4 people, but it's still, it's still. I mean, that's what you know. Personalities do interest people, and I think Edward Snowden knew he was not going to be able to keep his name out of it. So he did it, and then preemptively released his own name because it was. But he wanted to control it. Sometimes people want to do that with me, but occasionally I make the decision for them.
Mm-hmm. Other questions? Right here.
I was just wondering, going in a different direction, if there is a real policy about how you determine what you're going to ask and what kind of framework it's going to be in. My daughter, for example, is a lawyer for for California schools, and they've had so much trouble with reporters asking for information from students, and students thinking they should give the information, whereas, you know, there's been no consent by the parent that this is a child. You know, these kinds of things. There's always this case now of the 24-hour cycle that, you know, there are less and less, it seems, ethical policies and positions to take. You just want to get something fast so you can be the first or whatever. I don't know.
Dan, Christian.
It's sometimes a hard decision to make as to who you do. I covered schools for just a very short period of time, but I made a decision in general, unless it was something that I felt I could avoid. I didn't talk to students unless it was, you know, on educational policy or something like that. I didn't talk to them in some sort of confrontational way. But I am, and it's been discussed in the media recently, I like doing a thing called doorstepping. And it's an ugly process and most people don't like it, but if I need to reach somebody for a story, I go through every means that I can, and then I usually go to the person's house. And people throw me off the property. A former AG's candidate threatened to shoot me. But frequently, people will invite me in and sit down and talk to me because they think, okay, this story's going to happen, so I want to talk to you about it. And you know, I just did this on September 11th, and a number of news outlets have written about the fact that I did this with this attorney. But it was someone I knew, so I thought it wouldn't be as difficult. But you know, the process of reporting can be very ugly, and so we're wanting to get what we want. But you know, once you publish a story, people become critics. Everybody now is a critic with comments, and they're like, "Why didn't you do this? Why didn't you get this?" And so I try to go to every link that I can, just about to talk to people before I write about them or before I publish about them.
Other questions? Yes.
Thank you. So my question in thinking about Snowden, if he returns or if he had never left, if this was brought before the Supreme Court and they engaged, in an ad hoc balancing or a balancing of rights, looking at the First Amendment versus national security, do you think this freedom of information, the First Amendment, would have trumped the national security issue?
Well, all I can say is what we tried. In 2013, just a few months before the Snowden revelations, 5 out of the 9 Supreme Court justices threw us out in a 5-4 decision. We were challenging an NSA surveillance program that we thought was unconstitutional. On behalf of a bunch of human rights lawyers and journalists and others. And we said that this unconstitutional law was having a chilling effect and a burden on their work. And the government didn't argue to the court that the program was legal. It didn't defend it on grounds of legality. Instead, it said that we had no right to be in court, that we had no hard evidence that the plaintiffs in the case were subjected to NSA surveillance, that our lawsuit was based on pure speculation, and therefore we didn't have legal standing even to be there. And we couldn't use the legal process to try to get that evidence because the evidence was a state secret. And it was a kind of catch-22 that meant that no one would ever actually be able to go into federal courts to challenge the legality or constitutionality of these programs. And that happened every single time between 9/11 and 2013 when we went into a federal court to bring a constitutional challenge to a surveillance program, is that we ended up losing, not because the courts said the programs were legal. The courts never engaged in any legal analysis whatsoever, but because they said that we didn't have standing. Now, the very first document that The Guardian published based on the Snowden leaks was an order from the Foreign Intelligence Surveillance Court to Verizon Business Records, ordering the company to turn over on a daily basis all the telephone metadata for all of their customers to be stored for 5 years. One of Verizon Business Records' customers is the American Civil Liberties Union, and that little piece of paper was a ticket to federal court. And now these issues are being litigated, as they should be, on the merits in federal courts, and now we'll find out what the Supreme Court thinks if it reaches that point. Where do they think the balance is here? Do they think that the NSA and FBI went too far with this mass surveillance program? Some of the sponsors of the Patriot Act have joined us in this lawsuit in saying that the programs went too far. Or will they agree with the government that this is a necessary and reasonable and constitutional program? We shouldn't have had to wait for Edward Snowden to be able to have a court answer that question, but unfortunately we did.
I'm going to take one final question. Another student here. Go ahead.
So post 9/11, obviously, privacy is something that young people are okay with not having. You look at Facebook and stuff like that. And I heard somewhere that, the younger the generation, the more okay they are with the government or anyone knowing what they're doing because it's just what we're used to when we have smartphones. Do you think that eventually this is not going to be an issue because as young people become older people that we just don't care anymore? Or do you think this is something that is going to be forever relevant? And what can we do?
It's actually, your premise is emphatically untrue about whether young people care more or less about surveillance and privacy. And if you think about it logically, you'll know that young people have one thing in common. They all experience a lot of surveillance. It's called family and parents. And they get very good at contextual information channels. If you think about privacy as something that is revealed or something that is secret, I think you're in the wrong frame. Every day we disclose information to some people, even as we hide it from other people, which is why when someone's cell phone gets hacked or when somebody's emails get released through an open records law, a lot of deeply embarrassing things come out, things that were not secret because the person was communicating it to someone else, but certainly never intended for the entire public to know that. And I actually think that young people, if you look at the way that they use social media, for example, they're much more conscious than their parents and grandparents, who are also now using social media, are of who the audiences are and how to actually refine the way they're using it to make sure that they can communicate to who they want to communicate to, and that they communicate very differently to their immediate friends than they do to other people. So, no, I actually think that I have a lot of hope that because young people understand the technology, they're digital natives, in ways that the policymakers do not, that we're going to have a much more and not much less receptive audience for conversations about rights.
As a father of 2 teens, and I think in response to what you're saying, I think teens are more comfortable with how they control what information about themselves gets out there. But I think when information that you don't control gets out there, then the whole story changes.
Right. I think I'm going to wrap things up there. Before we say thank you to our guests, a couple of quick notes. Two more on the issues events this week. Tomorrow, quite a change of pace. We'll be talking with the Packers CEO, Mark Murphy, which should be a more pleasant conversation than it would have been a week ago, I will say that. And then on Wednesday, we're going to be releasing the newest Marquette Law School poll. So that, again, will be a 12:15 event. Having said that, I want to thank everybody in the room for their interest, for their attention. I especially want to thank our three guests. I wanted to say thanks to Dan Bice from the Milwaukee Journal-Sentinel, Krista Westerberg from the Wisconsin Freedom of Information Council, and Ben Weisner, attorney for Edward Snowden and ACLU. Thanks very much for being with us.